Good.
Okay, I think we're just about ready to get going. Hello, everybody. Thank you for joining us. Welcome to the UC Berkeley Law Reunion. I think this is the first program today, so we're very happy to have all of you here. I'm going to do some quick introductions of our panel, and just then we're going to launch into our program. Before we do that, let me just say a couple of things. One is that we're happy to have your questions. This is going to be an interesting discussion, and many of you will have some input that you might want to share and questions you might want to ask. So encourage you to just send them in the Q&A button, and we will do our best to monitor them and answer the questions as they come up. Secondly, you will be getting a sign in for CLE, which will be posted in the chat. So I don't know very much more about that other than what they just said, but monitor the chat and sign in, I guess, by the end. And then lastly, materials will be posted in the chat as well as on a separate website. So everybody, thank you, so much. Let me, I'll just quickly introduce myself. I'm kind of the moderator, but also a participant today. I'm Merri Baldwin. I'm a shareholder at Rogers Joseph O'Donnell in San Francisco. I am a graduate of this fine institution, class of 1989. I teach here. I am a lecturer. I teach professional responsibility. It's actually quite a thrill to be back at Berkeley teaching after having gone to the school. I'm sure many of you can relate to that. It's a much different experience too, let me say. My practice focuses on ethics and attorney conduct, which is relevant, of course, to what we're talking about today. I think all of our bios are in the chat. You can look at more details. Just relevant here. I'm the former Professional Responsibility and Conduct Committee, and I'm co-chair of the vice chair of the bar's Closing the Justice Gap Working Group, which you're going to be hearing a lot about in upcoming days. Now, let me turn to my esteemed panelist. Mary McNamara is also a class member, a member of the class of '89. She is a criminal defense lawyer in San Francisco. She runs a small and well-known boutique that specializes in criminal defense, particularly federal criminal defense and complex civil cases. Mary will be president of the Bar Association of San Francisco next year. And I want to note that she will be, I think, the fourth member of UC Berkeley, class of '89, serving as president of the bar. First was Jeff Bleich, next was Michael Tuback, third was me, and now Mary. So, keeping it up. How many more class members do we have? Quite a few. We're going to keep this going. And then last and definitely not least is Professor Michael Tigar. We're so happy to have Professor Tigar with us today. And when I asked him for a few bullet points for his introduction, he said something like, class of '66 from UC Berkeley Law. And I think he said something like he's going to be happy to be here today. So that tells you nothing that you need to know about Professor Tigar. He is an eminent trial lawyer and activist. His career really exemplifies the kind of aspirations that many of us have when we go to law school. And he's represented Angela Davis, John Demaniuk, Terry Nichols. The list really does go on and on and on. And I encourage you to read his bio because it is very inspiring. Now, he's also, of course, a professor. He's taught at, and Michael, I hope I can get all the institutions that you have been a professor at: University of Texas, Duke, American University, and I think there are probably others.
A couple more. The best, of course, was the law faculty at Aix-en-Provence every spring. Somebody has to be paid to teach in Provence in the spring, and that was my luckiest spring.
Well, yes, and something, again, inspirational to all of us. Now, what we're going to be doing here today is basically having a conversation, and the topic is the ethical limits of advocacy. The non-working title is dealing with difficult clients. And we've got a number of different ways that we want to talk about this and want you to think about it. So let me just give you a little overview, and then we are going to launch into a conversation. And let me just say, we have no PowerPoints. How refreshing is that for all of you? You can thank me later. And I'm thanking all of us right now for not having that. Difficult clients, and again, thinking about ethical limits of advocacy from that, framework. Difficult clients can refer to a few different scenarios. One might be the client who makes representation difficult, either because personality or because they want the lawyer to do things that aren't possible or that are not in their best interest as the lawyer perceives them. That's one type of difficult client that can put strain on an attorney-client representation, including, strain that can reach ethical dimensions. Another category might be clients who are reviled socially or politically because of their views or their actions. Both of my co-panelists can speak to the difficulty in representing those kind of clients. And then, we also have situations where clients who are difficult simply because, they've done difficult things, and that the situation itself is just difficult, not for reasons that really necessarily relate to the client themselves, but just to the circumstances. So I do want to just point out that, the ethical duties that we'll be talking about, I'm not going to go into the rules and depth, but I do want to just give an overview, because of course this is, what I always do as someone who teaches this. I want to make sure that we're all operating from the same perspective. We've got, of course, the duty of loyalty to the client, including the duty of zealous advocacy. We don't really talk about, we've kind of moved away from framing this duty as one of zealous advocacy, but in terms of how we talk about the rule, but I think it's useful still as a concept. The allocation of authority between lawyer and a client. You can see this in Model Rule 1.2. What decisions are the clients? What decisions are the lawyers? We have a part of 1.2 says that representation of a client does not constitute an endorsement of that client's views or political or moral views. So it's kind of an independence from the client in that way. We also have the ethical rule that lawyers may not counsel clients to engage in or assist in conduct that's criminal or fraudulent. This is going to become relevant shortly in our discussion. Duty of candor to the court, Model Rule 3.3. Requirement, and of course that requires that lawyers not knowingly make false statements of fact or law to the court or fail to correct a false statement of material fact or law previously made to the court by the lawyer. We've got Rule 4.1, which is the requirement that in the course of representing a client, a lawyer may not knowingly make a misstatement of fact or law. We have the duty to use independent judgment, which is not specifically captured in a professional rule, but is certainly one of the sort of fiduciary duties that are recognized in common law. And then lastly, just to mention, we have the rule that defines misconduct for lawyers, which is Rule 8.4, which includes among the definition of what constitutes misconduct, where a lawyer engages in dishonesty, in conduct involving dishonesty, fraud, deceit, or misrepresentation, or conduct that is prejudicial to the administration of justice. So that's kind of a framework, a loose framework of ethical duties that we owe to our clients in advocacy. And now I wanted to start us in on our conversation. So we've seen recent instances where lawyers have engaged in conduct on behalf of clients that courts or regulatory authorities have deemed improper and violating ethical and legal duties. And We've got the obvious examples, Rudy Giuliani, who was suspended on an interim basis by the New York Supreme Court Appellate Division, First Judicial Department, pending resolution of the numerous disciplinary complaints that have been made against him. And then in a related but slightly different context, we have the recent decision in Michigan sanctioning Sidney Powell and Lynn Wood and other lawyers involved also in the Trump election lawsuits for what the judge said there was a historic and profound abuse of the judicial process. So those two examples kind of provide a nice starting point for us in talking about ethical limits on advocacy. And they may also help illustrate the difficult client example, although of course, we can just make assumptions about that. I want to talk first about Giuliani and the decision by the court to suspend him on an interim basis. One of the things that the court cited as a basis for its decision was that he had communicated demonstrably false and misleading statements to courts, lawmakers, and the public at large. These statements were made to, quote, bolster respondents' narrative, meaning Mr. Giuliani's narrative, that due to widespread voter fraud, victory in the 2020 US presidential election was stolen from his client, end quote, and that his conduct immediately threatens the public interest and therefore warranted an interim suspension. So I'd like to throw out to my co-panelists here, in many ways, this decision is unusual. And I guess I would just ask you an open-ended question. What do you make of it? What implications does it have for other lawyers? And what concerns, if any, do you have? Merri, you want to start?
Sure. Thank you, Merri. I was taken aback a little bit by this opinion. First of all, it's notable, as you pointed out, Merri, that the sanctions really covered a broad range of not just statements to the court in the course of prosecuting a lawsuit, but also statements to lawmakers and the public. And it's remarkable in this opinion that it seems like only one statement of all of those was made in court. It was relating to the status of a particular claim in the lawsuit that Giuliani was prosecuting, that there was a fraudulent election, and he ended up withdrawing that claim. Admittedly, he spent a lot of time frustrating the court, and the court spent a lot of time disaggregating what Giuliani was actually prosecuting. And the court made a point of saying that its time was wasted and it had to engage in a whole series of due diligence efforts to try and make out what Giuliani was saying. And that was an interference with the court process. But it was just the one thing. And the opinion goes on to speak about all the egregious things that Giuliani said in the public sphere and to lawmakers. And so it does seem that that is a singular instance of a lawyer being disciplined largely on the basis of First Amendment protected statements outside of court. And I think it draws attention to the fact that we lawyers oftentimes are serving in dual capacities. We, of course, represent our clients in court, but we also speak for our clients in the broader court of public opinion. And that really is core First Amendment material. So I thought that the opinion was extraordinarily broad and far-ranging and troubling for that reason. And the second thing I think that was unusual about it is that, as you pointed out, this is an interim suspension. It is a suspension to protect the public, and it is done before a full briefing or a full hearing, and I think before Giuliani had a real chance to present a defense. So those are two things that struck me immediately.
So, Professor Tigar, I think this.
Yes, I would. Yeah. Yes, I would add that lawyer speech in court is, of course, subject to different rules than lawyer speech out of court. And the Michigan opinion documents what Giuliani did, and I think we put that to one side. Second, turning to lawyer speech out of court, the court held in Gentile versus State Bar, Nevada, which is at 501 US 1030, and you can look it up, and then you can see my oral argument to the court and my exchange of views with Justice O'Connor about the need for precision in rules that regulate lawyer speech. And while it's true under the revised Rule 3.6, the ABA model rule, that speech that has a substantial tendency to affect a public a judicial proceeding can be the subject of professional discipline. Nobody claimed that was going on here because there's no jury. And lawyers, after all, in cases of public concern, fulfill a double duty. Their expertise can be valuable parts of the public debate, which includes true things and false things and so on. And they're uniquely situated in that sense. And indeed, as we look at the history of the First Amendment, in 1761, James Otis, who was a lawyer, who was John Adams's law associate, made a speech on the Boston Common about litigation in which he was then engaged about the British behavior. Of that speech, John Adams said, "Then and there was the child independence born." So if you are an originalist about the First Amendment protection of lawyer speech, even the rather silly things that Giuliani said raise some serious issues. First, and you read the Gentile opinion, as to overbreadth, but more specifically as to vagueness.
And I think that these are both really good points. And I would encourage people to read the Giuliani opinion. We've included it in the materials today. Going to Merri's point, that it's just notable to see that the court relied on, quote, statements made at press conferences, state legislative hearings, radio broadcasts as both a guest and a host, podcasts, television hearings, and then, yes, the one court appearance. So, yeah, I think that there's a lot of potentially troubling aspects of this decision. I would also say, from the perspective of somebody who handles lawyer discipline matters, an interim suspension. I do think, Merri, that he was, from what I can see, and I don't know that much about the process in New York, he was given an opportunity to brief the issue of an interim suspension. He made some interesting admissions there. I
Yes.
don't,
He briefed it badly.
Yeah, it's kind of, the whole thing is just an interesting, and of course, this isn't the end. We'll be hearing a lot more about this. So let me, I guess, one more point about Giuliani. Of course, the basis of the court's decision is that he knew that the statements he was making were false and misleading. And that would be the whole basis, as I highlighted in the overview of the rules. That's what is necessary to violate the rule, is that a lawyer knowingly makes these statements. And, I think, that those all, for any of us who ever try to parse through, what it means to know something and what it means to prove that something is false, and to prove what somebody knew or didn't know. This could, notwithstanding what we might believe about what Giuliani said, it does raise some. You can easily imagine how this standard could be turned against people on the other side of the spectrum, political spectrum, and it does. It does raise some concerns, I think.
Yeah. On that point, Professor Kate Royfee of New York Law School, NYU, raises a really, I think, interesting point. She talks about the counterfactual situation of, let's suppose there was a stolen election. Let's suppose it was widespread fraud, and there was an effort by the administration to stifle discussion of that. Do we really want to have a situation where a lawyer is going to have to choose what she says in the public sphere about that? And I think just looking at it from that perspective, I think we all have a tendency to, when we care the most about the egregiousness of what somebody might have said, that's probably the time when we need to be the most careful. And I think this is a good example of how in perhaps the press to put an underline under Giuliani's, I think, utterly disgraceful conduct, we need to be careful about the power we give to disciplinary bodies to essentially silence lawyers.
Well, I agree with that. When I was doing the research for the for the Gentile case, I tried to find an instance in which a prosecutor had been disciplined for a press conference, and I could only find one. And that was a case in which a prosecutor had held a press conference saying, I think I got the wrong guy. I'm going to dismiss the case. And he was gone after for that. But the record documented in the two cases I put in, the Denver one and the Michigan one, is that these litigation tactics really are the bottom of the barrel. And I think that as we look at them, we ought also to remember that when powerful people, such as a sitting president and about to be former president, attempt to use the judicial system by having lawyers who are willing to go in and say things that aren't true and to make up stories, that's a time when the bar ought to get busy. In California, if you look, for example, let's go back to the Japanese relocation case. Solicitor General Fahey lied to the Supreme Court of the United States about whether or not there was intelligence reports about the so-called danger of Japanese Americans. The Innocence Project has now chronicled case after case after case in which people have been sent to death row because prosecutors refused to do their duty of looking into matters and making sure that their presentations were accurate. And so I look forward to judges disembedding from these proceedings the lawyer behavior. You mentioned the Demaniuk case. That was reported at 10 F 3rd 333. That was a case in which somebody was sent to stand trial for his life based on false evidence. So this too is an important part of what we're addressing today. Sometimes clients in their desire to see a result want more out of the system than it ought to have to give. And we as lawyers have got to be the ones that say, no, we're just not going to do that.
Yeah, well, that's a really good point. And let's segue slightly to the issue of the situation where lawyers are in a position where their clients want to do something, as to your point, either that the system can't really do. And we see this all the time in civil lawsuits where clients have unrealistic expectations about what a civil lawsuit is going to achieve for them. But also in a criminal defense context, where where the lawyer and the client might have fundamentally different views about what is the best result for the client, or what is the best strategic, never mind result, which is clearly the client's always to choose, but the best strategic means to use to try to get that result. So how do lawyers balance their ethical obligations to their clients and also to the court, and even just looking at the ethical obligations to the client, the duty of loyalty, but also the duty, of course, not to engage in fraud or misconduct, but also the duty of competence to use your legal knowledge and experience in a way to try to represent your client to the best that you see appropriate under the circumstances. How do we look at those kinds of situations?
Well, I think going back to the rules that you outlined at the beginning, Merri, I think probably the best guide here is the one that's not in the rules, so to speak. It's our fiduciary responsibility to have a separate identity from our clients and to exercise professional judgment that is independent. And to me, that is the key. The job isn't to satisfy the client's every needs or wish or desire. It's to bring our independent professional judgment and our competence to bear on the problem at hand. And the rules tell us that the client can set the goal of the representation, but it's up to us to consult and communicate with the client on the best means of achieving it. And I think the failures I see in many areas where lawyers get into trouble is in the failure to exercise that independent judgment. So if you've got a client who says, I want to do a scorched earth litigation strategy, that's not something you have to agree to. You can decline to do that, and you can educate the client out of that strategy. And if the client is obstreperous, you can fire the client for that. Similarly, if the client wants to use, say, a criminal forum in a criminal defense situation to mount a essentially political defense, there's a long history of doing that in this country. But there's also, I think, a duty to look at that independently and determine whether or not that fits within the rules of the court, the procedures, and your own independent professional judgment. So it's this need for a separate identity that I think is the guidepost. And I think it's the hardest thing for young lawyers to achieve. And it is why I think we all need mentors in the early stages of our careers to model that behavior, because it's not much talked about, I think, in law schools, or at least it wasn't, I think, back in our day.
Professor Tigar?
I think that Mary's hit on it. That is, the first job, of course, is communication. We need to take the time with each client to sit down and talk about what's going on. I've had cases in which somebody has said, well, suppose I just lost that calendar, you know, and then we wouldn't have to produce it. That's the time to have the conversation about, you know, you as a practical matter, I ain't doing it, but as a practical matter, you get caught doing that. And it doesn't matter if your case is meritorious, you're going down. With respect to political cases, you know, often we are called upon to present the client's life story in a way that illustrates some principle for which the client stands. And I mean, Fernando Chavez, Cesar Chavez's son, standing trial for resisting the Vietnam War. We talked to the jury about that and presented that as a part of the case, but it required a long conversation in which we had to go over a lot of details. And I flag here too, when we embark on a case like this, on behalf of the client, we may very well run into some judicial resistance. And our ethical duty is as much to stand up to the judge trying to shut us down when we do that, as it is to study and present our defense in a proper way. Grant Cooper got held in contempt. That's a leading California case. I wish I could remember the citation, but I'm too old. It's Cooper versus Superior Court. You can look it up. The judge tried to shut him down. And then there's that wonderful case of John Philpott Curran, the legendary Irish advocate, as to who the English judge said, Mr. Curran, you carry on in this way anymore, sir, and I shall be obliged to commit you for contempt. And Curran rocked back on his heels and said, well, then your lordship and I will both have the satisfaction of knowing it won't be the worst thing your lordship has ever committed.
Yes.
Sorry about the accent, Mary.
It was disturbingly spot on.
Let me, so this conversation touches on an interesting question, which is, we as lawyers have a duty to protect our clients. We have a duty to be independent and utilize that independent judgment on behalf of our clients. But how do we know, when our view of what the client's best interests are is a reasonable one? Mary, you suggested that, at a certain point, a lawyer could simply, terminate the representation or withdraw. And let's talk a little bit about withdrawal, because there are a lot of considerations that would come to bear on a lawyer seeking to withdraw. And I know you both have opinions about this, but I'm asking sort of a threshold question, which is, how does the lawyer know that they're, what is the point at which a lawyer decides I can't do it anymore. I can't continue this representation because I feel so strongly about my view about what is the best. Let's put aside if the client who wants to engage in fraud or something, because obviously that's a mandatory withdrawal scenario and let's not talk about that, but just a judgment call. How does the lawyer exercise that judgment? And when is withdrawal appropriate?
Well, it's a great question, and it's one that, of course, is never solved. We go through this as a learning experience in our entire lives, and I'm sure I've drawn the line in ways that I might regret sitting here today, and I'll probably draw the line somewhere else tomorrow that I might regret. I think it is an evolution, and I would just observe a couple of things. First of all, I think the important thing, is to understand what the danger signs are in terms of where you might be heading. So the client may not have asked you to do anything illegal, and you may have done nothing that you feel worried about, but there's something that tells you that day might come. And I think there are situations that I think are red flags. I think it is important for a lawyer who has only one client to be constantly vigilant for that dynamic, because if you are beholden to the lawyer, to your client, and the client asks you to do something, it gets slippery sometimes. It may not be an egregious violation that the client wants you to do, but there might be something that goes against your own moral compass. And the minute you start walking down that path, it gets very hard to come out of that path. I think similarly, sometimes in in-house corporate situations where you are a counsel to a company that may be a very hard charging company, fake it till you make it kind of company, the lawyer's in a difficult situation there because we like to color very well within the lines, and the corporate ethos where you might be is perhaps completely outside of that norm. And so those situations are ones where I think you just have to be very vigilant about what the client is asking you to do. I will say, on the other hand, there are situations, and I've been in some, where a client has disregarded my advice and done stupid things, perhaps even criminal things, while I have been the lawyer. And the question is, do I then withdraw? And it gets to your question, Merri, of what are the consequences of that? Because withdrawal under those circumstances puts up a gigantic red flag, and it really would harm the client's interests. And so you've got to make a judgment call about, can you do better inside the tent than you can outside? And I think those are judgment calls that we get through experience. And again, I think talking to one another. And if there's one thing I would just like to say above all in this panel, it is reach out to your colleagues, call Merri Baldwin. She'll probably pick up the phone, call people you trust, and make sure that you have a sounding board if you're alone in the world, because that's when we make bad decisions.
The last, Merri, all the things you said are spot on. That last note, picking up the phone and calling somebody, that is so important. And there are many times in complex litigation when my law partner, Jane Tigar, and I faced difficult situations, and we picked up the phone and talked it through with somebody to give us independent advice, because after all, we'd like to stay in the case. We have undivided loyalty to the client. Plus, we have undivided loyalty to paying the bills and putting food on the table. So getting that independent opinion can be decisive. Coming back to the first point, the DC rules, which is where I am and sit on hearing committees, very strong about a written agreement at the threshold of the litigation. And setting out in a written agreement at the litigation threshold the mutual expectations, not only about the fees, but about what's going to be done, is absolutely essential. And we've imposed professional discipline on people that have not done that because the fee, it was inadequate. With respect to danger signs and red flags, I've found that it's often solves the problem to sit down and talk to the client about the real world dangers of embarking on a particular sketchy course of conduct, because there's often this assumption, well, nobody's going to know. Well, as my mentor, Edward Bennett Williams, said, you know, there are no secrets anymore. There's just a 10-minute head start. And that's the way of the world, and you can't indulge that assumption.
So, and on that point, I mean, that's an interesting, remember at the beginning, I pointed out that Rule 1.2 prohibits us from counseling or assisting a client in engaging in, crime or fraud. But of course, the same rule also says that it's nevertheless permissible to talk through the consequences of such conduct with your client. So circling back to the importance of communication with clients, I mean, obviously communication is the way that we get to, advise the client about what our view is. And if we have a different view than the client, sometimes it is going to be a question of education, explaining to the client why we think it's extremely bad for him to take the stand, for example. Now, that's a constitutional right he gets to, but we certainly have an obligation to explain to the client why we think that's bad. Or, in the case that you just raised, Professor Tigar, as someone who might be, a client who might be suggesting that they may be engaged in something that's prohibited, we can't help them do it. And it's also helpful to explain to a client sometimes what the ethical limits of our advocacy are. I can't help you do that because it constitutes, in my view, it constitutes criminal activity. Why is that? And here's what's going to happen to you. Now, this kind of sort of discussion process and explaining the consequences also, you know, the obvious context for this, and certainly this is true in a law school class where it comes up, is when a client suggests that they are going to be untruthful. They're going to testify in an untruthful way on the stand. And, you know, the rules specifically recognize that a lawyer has a duty to remonstrate with the client. I love that word, remonstrate. When do we use that other than this context, right? We have a duty to remonstrate with our client to try to convince him not to do it, right?
Yeah.
And part of the way you do that is you explain what the consequences are if they do it, and that may be that the lawyer has to withdraw. So that was a kind of way to circle back to the withdrawal question. Professor Tigar, I know you have some views on, you know, the considerations that might go into a decision to seek to withdraw from a case, and wonder if you could talk about that a little bit.
You know, I have withdrawn from only one representation in all the years that I've been practicing law. And I can't go into details, but it became clear to me that the client and I were simply not going to be able to agree about steps 1, 2, 3, 4, including maybe some of the ones we're talking about today, but it just became clear that this simply wasn't going anywhere. And I approached that decision with a great deal of hesitation. My wife and I were in it. I'm not going to give any more details, but it's a big decision. And if you make that decision, that's just not something you can do. That's highly personal decision that each of us owe to ourselves. Then the next duty is not simply to withdraw, but to make sure in a criminal case that the client will be adequately represented if you do withdraw. Because that, you know, our undivided loyalty to the client doesn't go away at the moment when we're having a serious disagreement with the client about what to do next. And so, you know, that's the only practical advice I can give. And that's another one of those cases, by the way, in which I picked up the phone and talked to an ethics expert to guide me through the decision to make sure that I was not elevating my personal choices or my sense of discomfort above my duty of loyalty to the client.
Yeah, it's a really good point. A lawyer gets to, and if you look at Rule 1.16, which is the termination of the attorney-client relationship, it's a model rule, but this is true, I think, in most jurisdictions. You know, we relatively follow the structure. The first part of the rule sets forth mandatory withdrawal scenarios, so circumstances that require a lawyer to seek to withdraw. And then the second part of the rule, which is much more extensive, as permissive withdrawal scenarios, so circumstances that provide a basis for a lawyer to seek to withdraw. And among those are if the clients, you know, insists on a course of conduct that is morally repugnant to the lawyer, that is a permissive basis of withdrawal. And I guess I would I'm going to give a little comment here, which comes from it's partly the tension I feel sometimes when talking to students about these issues, which is this is a stressful profession. And it's stressful for a lot of reasons, some of which have to do with the very seriousness of the rights of our clients that we're seeking to protect. You know, when we think about the role of the lawyer, we represent our clients. You might say, well, sure, of course. We represent them. We stand in for them. We are their proxy and their mouthpiece in court and otherwise. And that's an important role. That's a huge responsibility. That's why we have such significant limitations on our role and our duties, because we have such power. And it is a difficult position to be in, and it's very stressful. Add on to it all of the other, you know, things that make a lawyer's job stressful, billable hours, you know, all of that kind of thing. And so, and the point here is lawyers have to take care of themselves. And if a lawyer does indeed find themselves in a situation where a client insists upon a morally repugnant course of conduct, that the lawyer, even if perhaps it's not criminal, it's not illegal, but the lawyer cannot do it. I think not only do you have the permissive withdrawal under 1.16, you also have to consider the conflict rules, 1.7, which says the lawyer has to consider whether or not they can ethically and competently represent a client free of the influence of other relationships or other considerations like a lawyer's own, strongly held beliefs. And, these are things that obviously a lawyer ideally thinks through at the outset of a representation, but they might not come up until the representation is moving along.
I want to underscore, though, that I've been, I got out of Berkeley Law in '66, so that's 55 years ago. Only one time in all those years have I felt obliged to try to withdraw from a case. All the other cases, and you can imagine, they got heavy issues. The undivided loyalty to the client and the desire to see the case through trumped. So, Merri, what you just said, this profession asks a lot of us, and it asks that we be prepared to give it.
Yeah, just on that score, it's a fascinating debate. I have also withdrawn from cases on a very, very limited basis. I've done it more than once, but I have fired clients pre-litigation several times. And I just think that I welcome the evolution of the rules. Merri, you talked about the rules recognition now that lawyers can consider moral and ethical, their own essentially conscience in whether or not they're going to pursue certain avenues. I think that's a good rule. I also think that, as you mentioned, the toning down of this notion of zeal is a good rule, because I think sometimes lawyers have brought the profession into disrepute, honestly, by pursuing things in a hugely aggressive way that have come to be seen as dangerous and undermining in certain ways, and I think have led to marginalization of certain groups. So as our profession becomes more diverse, I think it is important that we recognize that we don't need to always go in there and unquestionably champion a particular point of view, which is, I think, the way the rules used to come across. I think lawyers who are educated and experienced and had skill always understood that there was a different way to view the rules that way. But so I would just say we don't have to sacrifice ourselves on the altar of our clients at all costs to ourselves. So that's just one thing I would note. The second thing I would note is that in terms of communication, it sometimes takes more than one lawyer to handle a case. And when I was a federal public defender, we used to have a saying that this is a 2-lawyer case or a 3-lawyer case, where the client would come in and fire one of us and then the next of us and then the next of us, because the client just didn't want to hear the reality that she or he was facing. And that, I think, is an important thing to keep in mind, because sometimes our job is to educate our clients. I think there's a huge amount of education that a competent lawyer has to bring to bear in most circumstances. Even sophisticated people don't understand that when you go into court, you just don't lay it all out there and it's all quickly done and you get your results and Bob's your uncle. It requires an enormous amount of diligence, preparation, time, money, effort, and emotional strain. And there is a quote I like to think about a lot from Elihu Root, the great turn of the century lawyer, who said, half the practice of a decent lawyer is telling the client that he's a damn fool and should stop. And sometimes that is our duty. So I think you're right that by the time you get into the representation proper, you should have scoped all of that out, but sometimes you can't, because you might be appointed by a court to take on a client, you might be a public defender, you might be somebody who doesn't see the danger signs, but education and communication are usually the ways around that.
So here's a question. Yeah, go ahead.
Oh, I'd like to register a slightly different notion. When you represent people who are controversial, you may court dangers to your reputation and perhaps to your person. Jim Brosnahan did when he represented the so-called American Taliban. And I can remember in the Nichols case, the jury came back and had acquitted Terry of most of the misconduct, including first-degree murder and second-degree murder, which angered the families of the victims enormously. And it was over the holiday period, 1997, And we got death threats at the office. And my mother was in town to do her Christmas shopping, and she was followed around Cherry Creek Mall by a female United States Marshal carrying a great big gun in her purse just to protect my mother. I mean, that's just an illustration. But the fact is that despite the need to curb what might excessive and unprofessional zeal, I still hold with Lord Brougham that the lawyer's duty is to the client, to protect that client at all hazards and all costs, to all others, and among all others to himself or herself, he would have said these days. And then there's the rest of the quote. You can look it up. It's Lord Brougham. So if you're fortunate enough to have the opportunity to represent somebody who's really unpopular, just explain it to your law firm and go out and do it, because it's a hell of a ride.
Well, let me ask a question that was posed by the audience, and it relates to what we're just talking about. So we're talking about the need to advise your client and educate your client, in certain circumstances. But what constitutes the line between permissible advice and education to the client on the one hand, and what the questioner characterized as manipulation on the other? Like, how far can we go? Say your, client, really say your client's the Unabomber. Maybe that's not a good example, but it's an example where the client had a strong view about how to defend the case that differed apparently from the lawyers. And we don't have to focus on that, but just the question is, how does a lawyer know how far to go in terms of trying to educate a client to a particular view?
I think that's a question of experience, and that particular example is a very fraught one. It was a famously difficult example of a client who had an enormously high IQ and wanted to court the death penalty, and his lawyers essentially didn't think that was in his interest. And I remember being very caught up in that situation myself, because those are not as rare as we might think. And I'm sure Michael as well, certainly have had clients who want to do amazingly self-destructive things, or want to go to trial, for example, in a case where the evidence is overwhelming, and that there's going to be a conviction unless there's a miraculous appearance of aliens in the courtroom. And the consequences of that are a life sentence, whereas you could probably negotiate a plea and get that person a life after the case. And those are extraordinarily full cases. But just going back to what Michael says, I do think when it's a question of what the goal is, and especially if the client insists on going to trial and you've done your best to say it's not a good idea and you've explained it as best as you can, you don't have a choice. I think you have to accept what the client's goal is. But I don't think that means you don't keep trying up to the bitter end. And I think that I certainly think is our duty, just to keep pointing out to the client, you always have a chance to step off this conveyor belt, and I will always work very hard to help you in all aspects. So that's my answer to that difficult question.
First, we must always remember that the great scandal of the system that calls itself criminal justice is ineffective assistance of counsel. That is, lawyers who don't do enough or don't do anything, and that includes in capital cases. And so one can't confront the issues that the questioner presents until one has gone all the way down the road, because you'll find that the issue arises less often than you think. Second, of course we manipulate reality. I mean, for heaven's sake, why do we have trial advocacy courses? And without, of course, law professors say it's a Socratic method. They remember the result in People versus Socrates, so they really don't care about that. But the fact is that in the Terry Nichols case, we made sure that Terry was at the jury selection process, that he was dressed in a check shirt and chino pants and so on. We presented an image of him to the jury. When the Mitchell brothers of blessed memory were on trial, they were dressed up like, college freshmen instead of porn purveyors as they sat in front of the jury. And I think indeed that McVeigh's lawyers didn't get the point. He came across terribly to the jury. Well, what is that? That is the creation of an impression. That's what we do. So we shouldn't get to the point of saying, well, this tool shouldn't be used. This is a bridge too far, until we have conscientiously explored all of the intermediate steps.
And that's a really good point. The, again, going back to what we're talking about here, which the ethical limits of advocacy, in terms of sort of some of the issues that you're raising, Professor Tigar, where you're talking about kind of witness preparation and preparing your client for trial. There are interesting ethical limitations to that, but the limitations are pretty at the edge. They're pretty, if you've got a spectrum of permissible activities, what is forbidden is, influencing, causing a witness to testify falsely, basically. Yes. Up to that point, you're right. It's not only permissible, it's probably required. It's required that we do our best to present our clients in the best light. It's required that we practice their testimony with them, so that we, know what they're going to say and help them say it in the best way possible. Now, not to testify falsely, obviously. There's a difference, between kind of impermissible coaching and effective preparation. I think sometimes, students or younger lawyers, newer lawyers might be uncomfortable about the tools, some of the tools that are actually ethically permissible in terms of, what we can do to work with a client ahead of time. Now, I did years ago handle a malpractice case for a big firm where the plaintiff, former, tech entrepreneur, one of his claims was they told me to lie in deposition. Well, I don't think that's right, based on my knowledge of the clients. And then we, figured out what he was, and to the client, the lawyer's, frankly, ethically permissible suggestions of preparation in preparation for a deposition sounded like we want you to lie in your testimony. So that probably wasn't effective communication then on the part of the lawyer. But it is important to understand that we do have a duty. This is part of the duty of advocacy, is to get our clients ready and to work with them. And yes, manipulation, to a point. So that's not a question.
Yeah. Well, I would just note on that score, Merri, in Ireland and England, you can't prepare a witness in the way that we do here. It's absolutely ethically forbidden. And it always strikes me as an extraordinary disadvantage. And I think it's just not fair. And here's the reason why. I think we all know when clients come to us with problems, they come to us with a great deal of emotion about those problems, whether it's they're being sued or they want to sue somebody. And oftentimes they don't understand what arguments are going to win or what even is relevant or what's irrelevant, and how they might come across if they tell the story the way they tell it to you the first day in the office. It's probably a losing proposition. And so to just take the client in the raw and present that client on the stand in a system that is highly professionalized, highly technical, that has a whole group of rules about what's relevant, what's admissible, what's prejudicial, seems to be the most extraordinary abandonment of the client, in my opinion. And I think for us to do our jobs well, it's about witness preparation whenever they are put under oath, with the extraordinary penalties that come with making false statements under oath. That is our ultimate duty, is to prepare them very thoroughly. And I would say 9/10 of my job is preparation of witnesses who are going to be testifying. That's it.
Anything to add on that point, Professor Tigar?
No, except a hearty agreement. I wrote a book once called Examining Witnesses. You can look at it. But the courtroom is the most artificial place in the world to have a meaningful conversation about anything. The witness can't tell her story. She has to answer. She can't do narrative, and you have to do it with non-leading questions. The cross-examiner experts encourage you to use short, sharp questions that elicit one-word answers. I mean, it's a miracle that the cases turn out responsibly as often as they do. given the kinds of limitations that are imposed on the process of communication. So of course, there's a great deal of artifice involved in it, and our preparation of the witness to present herself as she is and wishes to be understood, and to get through that screen and all of those rules really does require a great deal of preparation.
So let's shift gears slightly and talk about the client who is difficult, maybe because of an offensive personality. Maybe they're difficult, maybe they're mentally ill, maybe there's some competence issues, or the client who might be difficult because they occupy such a position of power. Merri referred earlier to a situation that might involve that, because say it's your sole client or a very wealthy client who might hold a lot of cards in terms of governing the attorney-client relationship. What are some considerations in representing a client who, well, let's just, I guess, focus first on these sort of what used to be called offensive personality. We don't really talk about it in those terms. Actually, offensive personality used to be included in the lawyer regulation. Lawyers weren't allowed to have offensive personality, which is humorous at best, and of course, it no longer exists. But we'll just use that term. What are the considerations that come to bear when dealing with a client who is just plain difficult to deal with?
Merri?
Do you want to take that first?
Well, all right. First, I mean, I think they can be categorized. First, corporate executives. They have drunk the company Kool-Aid, and they come across as arrogant, uncaring, and so forth and so on. Perhaps that's a set of principles by which they live their lives, but I have actually taken appeals from cases in which corporate defendants in civil cases have just lost, and you read the transcript and you say, oh my God, who prepared that person to testify? So that's the first category. And then the second kind of category may be a person whose method of communication, habitual method of communication, whether it's cultural or based on some potential gender prejudice or based on any number, let's just imagine any of the number of prejudices, require that the preparation time be at great length. Edward Bennett Williams, who taught me this stuff, was a fan of getting in a room with the client and having 5 or 6 different people try different approaches at mock cross-examination to try to explore all the ways in which the witness might display some aspect of personality that was going to turn off a member of the jury. And final point, not take too much time, remember the speaker and the hearer. In this post-Batson day, we have jurors who are drawn from a much broader section of the cross-section of the community than before. We are talking about persuading 6 or 12 people, and we have to be alert to the fact that how the client comes across is going to affect each one of those people, perhaps in a different way.
Yeah, I think I like the way you divide the clients into the offensive personality, perhaps the powerful. I think what that comes down to in the first category that you're talking about, Michael, is client control, which is, again, a skill that you hone over the course of your career. And I'm reminded of that scene in the King's Speech where the king, who is a stammerer, goes to a speech therapist, and the therapist insists on calling him by his first name. And the king is aghast at such an extraordinary breach of protocol. And the therapist said, there has to be equality in this room if I'm going to help you. And that stuck with me because I think that's what we as lawyers have to do when we're faced with a powerful person who's used to pushing other people around and who's used to getting his or her own way and who expects ultimate deference. It goes back to our duty of independent professional judgment. And unless you can get that person's respect, you're never going to be able to control that person. And that will leak into every aspect of the representation. So I think our duty is to be frank, forthright, and to exercise some power to get that person to understand how she or he may come across. And the instance I can think of where that didn't seem to work was in the Microsoft litigation in I guess, the 90s, when Bill Gates famously was videotaped in his deposition, and he came across as a total jerk. And I think that really affected the outcome of that case. So I would say, on the one hand, you've got the corporate executives, but I also think you've got other people in that category of offensive personality. And I'm sure these are the people you're thinking of, Merri, who are extraordinarily manipulative, sometimes dangerous, and they will try to bend you to their will. And the first thing I would say is, don't ever take on a client like that when you're a young lawyer, because you just don't have the tools to be able to handle somebody like that. And the second thing I would say is, decide early on what you're prepared to do and not. And so I think, again, it's a slippery slope proposition. Manipulators are very good at inching their way in, and it may start out with asking white lies and accommodations and things like that, and pretty soon you find yourself finding it difficult to figure out where the line is. And that takes, I think, a degree of personal fortitude that comes with experience in the profession. And the final thing I would say is, don't do it alone. If you've got somebody like that who you're dealing with, try to get a colleague to help you, because it's very difficult sometimes to withstand a barrage. And I'm thinking here of Trump, all the ways in which Michael Cohen was asked daily to do the little things that on their own may not seem that bad. But by the end of it, he's mortgaging his house to go in a scheme to disguise a payment to Stormy Daniels, which is a campaign contribution violation. And it is the sum total, I think, of a lifetime of small paper cuts that ended up completely tanking his career.
And I guess I would add, as a slightly different example of some of this and the ways in which it can affect a lawyer, it would be the client who is just truly not a good person. They're a difficult person. They call up, they yell at your secretary. They're always nitpicking. They're unpleasant. And there are plenty of these people. These people get into trouble. It's not an accident that personality type may lead to litigation in which you find yourself representing them. And I think it's important ethically that lawyers understand their role and the effect that this person might be having on their willingness to engage, and might be affecting how the lawyer feels about the representation and what the lawyer is willing to do. And the lawyer has to be very careful not to let that happen, and has to take steps. If you've got a really difficult client, you've got to figure out a way to try to deal with that. Bring in a colleague, yes. Sometimes, and I've had these people, I represent lawyers for Pete's sake. I sometimes just have to say, you're being very unpleasant, and this is affecting our relationship. And I can't function with you basically yelling at me all the time. That's just not a relationship that is conducive, and it's not protecting your interests. So sometimes, part of the theme here is lawyers being very self-aware about what their duties are to the client, and how other factors, including sometimes the client, him or herself, may be affecting those duties that we owe.
I like to talk to clients about the question of who's going to decide your case at the end of the day, if we're going to go to a jury or a judge or whatever. And whoever that is going to get a picture, not just of what the issues are, but of our team as a whole. Litigation is a team sport. And we, for instance, when we're in court, we always treat paralegals and secretaries with enormous respect. We don't display any behavior that looks like we're condescending. And that's what we expect out of you in this relationship. That right now we have to begin as we mean to go on, as the Victorian woman said, by practicing a relationship that's healthy and mutually respectful. And if we can't do that right at the start, then this isn't really going anywhere. And the funny thing is that clients, particularly facing criminal indictment, seem to understand that. Merri McNamara, I guess you both had experience with it. I mean, I can remember the congressman who, a very right-wing congressman, potential client, brought in a right-wing friend of his. And he finally said, his friend said, okay, I'll defend your right wing and Tiger will defend your left wing. And the congressman said, no, I want my ass defended. Wings play no role in this process.
Well, I'm tempted to ask what happened, but I don't want to invade the attorney-client privilege. So,
Yeah.
Let's talk for we have a few minutes left, and this has been very fun. And thanks to the audience for sending in some questions. I've basically incorporated most of them, I think, into the questions that I've posed to the panelists. So thank you for that. You mentioned earlier, of course, Professor Tigar, the socially reviled client, someone who just has done something really wrong, Harvey Weinstein, many of the clients that you've represented, who are just very unpopular is a polite way of putting it. Maybe because they are accused of doing something really reprehensible, or for other reasons. I mean, Mr. Giuliani right now might fall into that category in some sectors. How do lawyers, obviously representing someone in that situation goes to the heart of what lawyers' duties are. And there are a lot of things to say about the necessity to provide representation to those kinds of clients. And Professor Tigar, you've mentioned the satisfaction and the value of representing those kind of clients. But what are some of the considerations that lawyers should think about in considering whether to represent a client in that situation? And what makes sense in terms of taking on that representation?
I think that one must find a level of generality of stating the fundamental proposition that one finds acceptable as a basis to go on. A level of generality that may exclude aspects of the client's behavior that's undesirable or unpopular or isn't going to get us anywhere, and focuses on some point or points that we can make that are persuasive and principled. And I've been thinking here about Fernando Chavez, Cesar's son, being tried to a jury in Fresno, California, where the judge wouldn't take the growers' employees off the jury. Was it a story about the Vietnam War? Was it a story about, opposition to that? No, what we made it was a story about Fernando and Cesar walking in the field one evening as Cesar talked about his principles to his son, and his son decided he was going to resist the war. And in telling the story on the stand, the son began to cry. And pretty soon 4 jurors are crying. We had chosen well the point of generality or generalization at which we needed to talk about this case, which turned out in the end to transcend what all of the other issues that might be hanging around there, including issues about the war and what these jurors felt about Cesar Chavez and the rest of it. And the prosecutor didn't get it. His cross-examination focused on Mr. Chavez. What would you do if a Russian soldier was raping your wife? On the pacifism. 25 years later, the judge came up to me and said, "You think you won that case?" I said, "Well, I do." And he said, "No, you didn't. That dumb son of a bitch lost it." And that's because that prosecutor couldn't find a way to distill out of the case a principle in which to go forward.
Merri, have anything to add on this?
Yeah, I think that's exactly right. And I would just say, when it comes time to try cases like that, the court is your friend, particularly, I think, federal court with its sort of cinematic dynamism. You have marble everywhere. You have the judge exalted like on Mount Olympus, 10 feet above you. The jury box is elevated. There are these very clear insignia of the power and might of the state. And you represent an individual against that power and might. And if you do your jury selection well, you can invest the jurors with that sense of the awesome power in their hands and the need to take seriously what's happening. And that, at its very base level, is a principle in all criminal cases. And I think in many civil cases, you still have the state adjudicating and the power of 12 strangers coming in and judging. And if you can imbue what you were doing, either through your person, the way you conduct your case, the way you present your client, with that level of seriousness of the enterprise, you can actually forge ahead and do the beautiful thing in our profession. And I would just say, I think our profession is a very noble one. I am proud to be a lawyer, even though our profession is in disrepute a lot of the time. It's come out of the dustbin a little bit, I think, in recent times during the Trump administration, when lawyers were seen as protectors of the Constitution. I embrace that. I think it is a noble thing to do. And I think we should constantly tell ourselves that story, that we are doing a noble job, even in representing reviled clients. And if your question, Merri, is, what are the practical implications of doing that? They're intense sometimes. You can lose clients, as Brosnahan did, and I think his decision to represent the young man, John Walker Lind, accused of terrorism, was an enormously controversial one at the time, when 9/11 was a red hot idea. And I think he was extraordinarily brave to do it. But I would also say leaders in our profession need to be doing this, because only when you blast open those prejudices can the rest of us function in society. So that's my long-winded answer.
Okay, I like it. I like it. Let me, we have about 3 minutes left. So I want to circle back to where we started with our friend Rudy Giuliani, and just ask the two of you, and I'm springing this on you. We didn't practice this or discuss it at all in our prep sessions. So I'm interested in your thoughts. If Giuliani came to you during all of this, while he's going on TV, while he's doing his podcast, while he's appearing in court, and asked you for advice, what would you advise him? Understanding, let's just assume he's getting directions from a difficult client about how he needs to be. And so beyond the obvious of don't make misrepresentations on TV, but what are some considerations that you would provide to Mr. Giuliani in that, or someone else in that difficult circumstance?
Gosh, well, taking Giuliani aside, I mean, I would want to have a conversation with somebody in that situation and really say, what are the objectives of your representation of this difficult client? What are you trying to achieve? And if what you're trying to achieve is to throw a bomb in the democracy and throw scare tactics out there, I would not represent such a client. If what is trying to be achieved here is a legitimate set of lawsuits tackling a question, I would really want to see the filings in those lawsuits to avoid Rule 11 sanctions. And none of them had a whit of merit. None of them pursued a legitimate extension of the law. Many of them relied on facts that were clearly wrong. So I think my first piece of advice is don't file a lawsuit, because you're going to get involved in Rule 11. My second piece of advice is, if you do insist on going on the airwaves, try to have it as decorous a discussion as you possibly can. Maybe you can raise questions, but to be stating categorically that there is, dead people are voting in Pennsylvania and that sort of thing, maybe not sanctionable as a lawyer, but it's going to tank your career. And I would then be fired for giving that advice, I think, Merri.
Professor Tigar, any thoughts on this?
No, I know Rudy Giuliani so many years, in so many incarnations, that would not be a representation that I could in good faith undertake. I just couldn't. I think, and it wouldn't be any service to him. I do want to circle back to what Merri said about juries. Juries will punish you if they think you're trying to hide the facts or pull a fast one. That brings that noble idea of talking to the jury back to where we started here. There are disciplinary rule enforcement mechanisms that go beyond bar counsel.
Well, on that note, I want to thank the two of you for a really interesting conversation. I want to thank the audience for tuning in and sending in your comments. And I want to, of course, thank UC Berkeley for having us and for being our alma mater among the three of us. So thanks very much. And, I look forward to the rest of the panels.
Thank you.
Thank you.
Bye.